The chairman of the full committee, Mr. Jordan.
Thank you, Mr. Chairman. Ms. Atkinson, you wrote stories critical of the Obama administration. Is that accurate?
Yes, but may I point out it wasn't put in a political light, and there were also stories that some would consider critical of the Bush administration.
Well, let's say it this way. You wrote stories critical of the government.
Yes.
Yeah. You factually reported. And then you did on Fast and Furious, you did on Benghazi and other issues.
Yes.
And even before, as you said, on the Bush administration. And then strange things started happening to you, right?
Yes.
Yeah, like your computer, you think your phone gets bugged, you believe, and things happen to your computer after you wrote stories critical of the government.
Right.
That's scary, right?
Yeah, it's not a
frightening
comfortable
everybody.
feeling, right?
Ms. Herridge, you wrote stories critical of the Biden administration. Is that true?
That's fair.
I mean, you wrote a number of things about the laptop issue, about Hunter Biden, all kinds of things. You wrote critical of the Biden family, the Biden business operation, the Biden brand, and all that stuff.
Congressman, I reported out the facts of the story.
You sure did.
I
You sure did. You reported the facts. And then CBS fired you. Is that right?
My position was terminated.
Yeah. And you're an award-winning journalist. How long did you work at CBS?
I worked at CBS News for 4.5 years. During that period, we won major awards. I was part of an Emmy-winning team. I was nominated for investigative Emmys. I think the most important projects were projects that drove legislation here on the Hill that positively impacted 1 million veterans.
So award-winning journalist, won all kinds of awards, had worked there almost 5 years, had extensive experience at a different major network prior to that, where you were also an award-winning journalist, done all kinds of reporting critical of the government there as well, and then you get fired. But it's worse than that, isn't it? Because they didn't just fire you. What else did they do?
On February 13th, when I was told on a Zoom call that my employment was terminated, I was locked out of my emails and I was locked out of the office. CBS News seized hundreds of pages of my reporting files, including confidential source information.
And that's not normal, is it?
No, that's not my experience in the other two networks that I've worked at or with my colleagues at CBS News. When the network of Walter Cronkite seizes your reporting files, including confidential source information, that is an attack on investigative journalism.
Yes, it sure is. I'm just trying to, it seems to me there's a pattern developing here. You're critical of the government, Ms. Atkinson situation, and shazam, they start doing all kinds of strange things to your phone line, to your computer. You're critical of the government at a major news organization, and you're an award-winning journalist. You've been there 5 years, you get fired. But it's not just you got fired. In fact, we can, maybe there's nothing to that. But what we do know is they seized your documents. That's scary as well. And you talk about a chilling effect on the First Amendment. I don't know how it could be more chilling. Now, thank goodness the lady sitting beside you, they stepped in, right? Because they're stepping in and helping. Them stepping in help you get because you got your files back finally, didn't you?
I did get the files back. If I didn't have the support of SAG-AFTRA really publicly standing up for journalism, I don't believe that I would have received the files and they would have been returned. And I just want to be clear, Congressman, wherever you work, if this happened to you, it's an attack on free press. It's an attack on the First Amendment. It makes it more challenging for reporters to work in the future. That disrupts the free flow of information to the public. They call it journalism a profession for a reason, because it's about an informed electorate, and it's a cornerstone of our democracy. I can only speak for myself. When my records were seized, I felt it was a journalistic rape.
Ms. Cavallaro, have you ever seen that before, where when someone is leaving an employment at a major news organization, they seize their documents?
I can't say that SAG-AFTRA is familiar with every single case of termination or departure where—
I'm not asking that. I'm saying, have you ever seen anything like this?
I have no recollection of seeing—
Well, that should scare us too. First time it ever happened, and it happens to an award-winning journalist who's been in this profession for a number of years, known all across the profession. And that happens on the heels of what happened to Ms. Atkinson, because both journalists were critical of the government. That's exactly that's what journalism is about, being critical of the government when the government's doing things wrong, and then to have a major news organization or the government itself do this. In your testimony, Ms. Herridge, you had a very important line. You said, if confidential sources are not protected, journalism is dead. And I agree, but it would seem to me if retaliation is allowed by the government or by some major media outlet, journalism is dead as well. That's what this hearing's about. And I again want to thank you all for coming and sharing your important testimony. I yield back.
I thank the chairman. I'd like to recognize the ranking member.
I just have a unanimous consent request to enter into the record Paramount's response to Chairman Jordan's February 23rd letter regarding Ms. Harridge's termination. It corrects the record on some of the wild speculation and mischaracterization we've heard from the other side, as it describes that Ms. Harridge was not the only person who was let go at that time, and that certain procedures were followed.
The chairman, you have just for a second?
Gentleman from Ohio.
I didn't. All I said is it happened, but what happened afterwards is what's scary. When they seized her files, that is scary, because that's the point I tried.
Unanimous consent to introduce the letter.
Without objection.
Thank you.
Suspend for 1 second. So, in agreement? Do we want to go ahead and just proceed?
Okay, fine. It's not
I will now recognize the ranking member for questions.
Thank you. And I want to thank all of our witnesses here today. I appreciate Ms. Harridge's repeated acknowledgement that her employment dispute is separate from the civil lawsuit in which she was held in contempt for refusing to disclose a confidential source, despite the apparent confusion of some of my colleagues where they conflated those two matters. It's clear, I think, that the contempt was the result of a private individual's lawsuit seeking that information. It wasn't a government action seeking that information until it got to the point where the courts were enforcing a contempt citation, which brings us back to my remarks at the outset, which is that with the federal law in a state of muddiness, confusion, disarray since the Brandsburg versus Hayes decision over 50 years ago, it really is incumbent upon Congress to take action to make sure that the courts are not put in a position where they are exerting fines or possible jail time against journalists because they don't think they have the authority not to. So in Brandsburg, the court explicitly invited Congress to, quote, determine whether a statutory newsman, I would say, and women's privilege is necessary and desirable, and to fashion standards and rules as narrow or broad as deemed necessary. So, Ms. Johnson, if you could just take us through why should Congress step in and actually take up this invitation, particularly in the context of the recent threats to the First Amendment and freedom of the press in our modern world?
Congress should absolutely take this up because it is, in fact, confusing, and it leaves journalists in alert where they are going to be subject to, have been subject to, different interpretations of this seminal case that, as you note, is over 50 years old. But with the Press Act and with the definitions it provides and with the comprehension with which it addresses this issue, it is really an opportunity for Congress to clarify and to offer that certainty to journalists and to offer certainty to sources who, as we've heard from our colleagues on the stand here today, are going to be less and less likely to come forward. And that ultimately harms Americans because when Americans don't have access to information, they cannot understand what their government is doing. So it really is, it is a comprehensive approach that needs to happen as quickly as possible.
And I appreciate that. I think it also harms our court system when we're putting our courts in the position where they are doing something that is then undermining First Amendment and free press rights. We've noted, I think, that dozens of our states, I've seen 49 states, I've seen 32 states. So the majority of states in DC have now enacted shield laws, but they are not uniform. And of course, we have the federal circuit courts, which have a variety of interpretations of what's required or not required. How does that impact journalism in this modern age where so much of it is digital and online platforms, and we're not talking about the mom and pop paper down the street anymore, but we're talking about wider distribution sources? How does the lack of a more uniform shield law impact journalism?
It impacts it in a few ways, and I will say that the 49 states plus Washington have either a shield law or a court recognition of a reporter's privilege. So there's the distinction there. But actually, I think it's important to bring this down to an example, because the DOJ recently put into place media guidelines that talk about what a member of the news media can or cannot be subject to in terms of the limitations as to what the government can do to compel sources. However, the Justice Department's internal criteria give the agency substantial latitude when it comes to defining what a member of the news media is. And as I noted in my testimony, in this digital age, we have a number of individuals who are engaging in legitimate journalistic acts who might not fit a traditional mold in terms of being, for example, a Wall Street Journal reporter. But it is important that we recognize that because we are now in an age of new technologies and new opportunities and innovations in journalism, that having the Press Act with this broad definition to protect journalists of all different types of stripes will be important to ensuring that assurance for journalists across the board.
Well, again, I want to thank all of our witnesses for helping us reemphasize the importance of the Press Act and hopefully persuading our senatorial colleagues to get with it and help us get this done. So thank you.